Welcome. This is One-Timers, and we're going to take a look at question 5 from July of 2012. It's a Wills question. It's a very short fact pattern, but don't be misled by shorter fact patterns. That doesn't necessarily mean that they're easier. In fact, I like longer fact patterns. They give you more facts to work with, which means you can find the law in the facts. You can also find all the elements of each rule if you look closely at the facts. We'll get into that a little bit later, but let's take a look at this question. It says, what rights, if any, do Dot Sam have in May's estate? So there's only two people making a claim. We have D's claim, or you just put D, and then we have S. So we have Sam and Dot. And those are the two people. And this is what I would do if you're outlining before you start writing, which is an unbelievably good idea, because you should read the fact pattern 3 or 4 times before you ever start writing. So we're worried about Dot and Sam, and we have to take each one in turn. But if you notice, we've done, this happens on contracts, community property, wills, and a lot of other subjects. If you look, the first paragraph starts off in 2004, second paragraph in 2008, third paragraph in 2010, fourth paragraph in 2011. Just go date by date. If you're having any trouble organizing, whether it's contracts, wills, community property, or any other subject for that matter, things are usually in chronological order, especially when there's no call of the question or like numbered call of the questions. So just discuss what happens in 2004, discuss what happens in 2008, 10, and 11, and then you can figure out what's Dot's and Sam's rights. Okay, so in 2004, May, a widow, so the reason why they're telling you a widow is they're like, do not discuss community property. That's the examiner's way of doing it. Also notice that I forgot to mention that the last phrase is answer according to California law. If you're being asked to answer according to California law, they can only be 4 subjects that they're getting at: wills, community property, California civil procedure, and California evidence. You know, I know professional responsibility is both ABA and California, and that'll be a completely different issue or sentence. But answer according to California law, it's not trust, it's only wills or community property for the most part. And this one, because they're saying she's a widow, no community property. Little things like this will help you, will save you time writing. Okay, executed a valid will. So in 2004, we have a valid will. We don't know how it was executed, but it's okay. Don't need to discuss formation right there. Now, don't forget, formation, revocation, and pre-term children are the 3 most heavily tested issues in wills. You're going to discuss one of those, possibly both, maybe all 3, in almost every single essay. Valid will. Intentionally leaving out her daughter Dot and giving 50% of her estate to her son Sam and 50% church. So here we go. We have 50% here to Sam, 50% to church, probably a cult. We don't really know. And you can intentionally leave out your daughter. You can't only leave a will specifically disinheriting somebody. The will actually has to devise property somehow, which is exactly what it's doing. So the 2004 will is valid, just like the examiners say. Hey, we knocked out one leg of this, not too bad. In 2008, after a serious disagreement with Sam, May announced that she was revoking her will and then tore it in half in the presence of both Sam and Dot. Now, their presence is pretty much immaterial, but in 2008, we have revocation by physical act. And there's different ways. You're going to learn the statutory language. It's pretty simple. Burned, torn, obliterated, destroyed, however you want to say it. Revocation by physical act, we have a tear. So once she tears it and physically destroys it, the will cannot be revived under the doctrine of revival. It can, however, be incorporated by reference or integrated into a new document, but it cannot be revived in the technical sense. So we have a revocation and physical act. If she died right now, if Sam just put a bullet in her and ended us all, we wouldn't have to discuss this anymore. Thank you, Sam. But she would go, all the things would go by intestacy, which means DNS would get it 50-50. At this time, I'm just saying. Now, 2010, this is where the crux of the essay goes. So let me do this. Let me move Sam over here. So we have D and we have S. And 2010. We see how easy and how fluid it's going if you just take our time and go step by step and don't rush it. Go fast, but don't rush. Be quick, but however that expression goes. After repeated requests by Sam, May handwrote. So the word handwrite is it's holographic. And for a holographic will, you need to have the material portions, which are the gifts and the bennies, beneficiaries, and then you have to have signature. That's it. Pretty simple. You need two things, the material provisions, material portions of the will, provisions actually, and it just has to name the gifts and the beneficiaries, and it has to be a signature. As long as it's in her handwriting, great. So that's the next issue, is going to be the holographic will. Declaring that she was reviving her will. Well, she can't revive it, but there's other doctrines that will make it valid. She attached, and that's the key word for integration, attached. So the next thing is integration, because she attached. When you think of the doctrine of integration, think of stapling or paper clips. You just put everything together. I have a bunch of papers here. Let me just integrate all these by putting them all together and putting a big clip on them so that they're all integrated into one technically it'll be like almost one document. You've done that before with your notes in school and with anything. That's as simple as the concept is. I mean, it's interesting because these concepts on the bar, it's everyday life. You just haven't thought about it in those terms. And once you start thinking about it in those terms, wow, it's really simple. So integrated, she attached all the torn pages. Okay, she attached them of the will to the document. At the time she signed the document, which is in 2010, so we know it's signed, she was entirely dependent on Sam for food and shelter and companionship. Guess what they're getting at? And had not been allowed by Sam to see or speak to anyone for months. So stop right there. We'll get to the church out of existence in a second. So now integration, what goes to integration is incorporation by reference, because the handwritten document is incorporating the ripped up, torn pieces by reference. So in order to have incorporation by reference, the document has to be in existence, which of course it is because it was from 2004, it was 6 years ago. And the second thing is, it has to be sufficiently described, which doesn't really pose a problem here, because it says she attached all the torn. So with the incorporation by reference, if it's in existence and sufficiently described, and it seems that under one of these two doctrines is going to get in. I don't care how your analysis goes, because nothing really says that it isn't sufficiently described or that it is. We don't know exactly what she wrote, but she did say she was reviving her will. So I'm assuming she's reviving this will. Maybe it was a little bit more specific. That's really not what the examiners are looking for. They just want to see if you understand the doctrines, and is it sufficiently described. Your conclusion on that is pretty much immaterial. Now, with the facts, and this is why you don't need checklists and why you don't need templates, you just need to read carefully. Repeated requests by Sam, entirely dependent on him for food and shelter and companionship, had not been allowed to speak or to see anyone for months. If you can't see undue influence, you don't deserve to pass. You don't deserve to be representing people in court. So here we have undue influence, and there's two types of undue influence. The first one, we'll just go to the common law undue influence, which we have soup. It's one of the few mnemonics that I use. She has to be susceptible. And spell check will get that. Then it has to be a natural position, a natural disposition. I forgot about opportunity. Now, these aren't elements, these are factors, and then participated. Okay, these are factors, which means you don't have to show them all. Like, they don't all have to be proven. Elements, have to be proven. Like, for duty, breach, causation, damages, those are elements. These are just factors, which means the court's going to consider all of them and then kind of make a judgment based on what they think. So let's think about it. Is she susceptible to it? Well, I think this bat is pretty old. Let me see what we have here. How is she susceptible to? She was entirely dependent on him for food and shelter and companionship. So that's what makes her susceptible. Like, this guy's kind of running her life. Like, Sam is actually kind of in control of her mind and her. I mean, if you were feeding me food, if I was totally dependent on you for something, I'm kind of at your mercy. Opportunity. Did he have the opportunity? Well, yeah, because she wasn't allowed to see or speak to anybody. I mean, that was his opportunity. He enclosed her. He kept her away from the outside world. And so he really kind of deprived her of her free will in a sense. Unnatural disposition? No, not necessarily, because it's her son. And nothing's wrong about giving all your money to your son. I mean, don't forget, in her 2004 will, she gave half to son, half to church. Now that church is out of existence, there's nothing unnatural about her giving everything to son. So that's a factor the court's going to look at, like, well, but then did he actively participate in it? Oh, yeah, because the repeated requests. So you see how you can find the factors by just using the facts. So we have repeated requests. And again, these are all in the facts. Son, opportunity, was susceptible, dependent. And he was there. He was there and isolated. Because she had not been, she hadn't, what does that say? I don't even know what I just wrote. Oh, he was there. He was there. So think about it. If you have trouble finding the law or what factors are, or look at the facts, what are they trying to tell you? I mean, how is she, it's a great way to look at it. Then we have our statutory presumptions, thanks to, I think it was a lawyer named Gunderson back in 2003, where he ripped off a bunch of people from Leisure World. I'm sure you probably listened to that in the lecture. So we have this statutory, California statutory undue influence. Now, there's three different, it could be any one of these. Number one, the person who drafted the instrument or someone related to the drafter. This Gunderson guy, I hope I'm saying his name right. If I'm not, someone will edit it out, I hope. He went over to Leisure World, and he had stolen about $200 to $300 million by having people write wills, making it out to him. Well, he's accumulating all these assets, so he's had to get smart. He's like, I can't just keep having all this money come to me. So he would give it to his relatives, like his wife, his children. So these old people that were dying with no family, he was their lawyer, and he had them make out wills to his own family. And that's why it says, for the statutory, it has to be the person who drafted it or someone related to the drafter. Undue influence, heavily tested. Holographic wills, heavily tested. These documents, fairly tested. So we have drafted or someone related to the drafter. The second one is if you stand in a fiduciary relationship, some kind of confidential relationship. And that means you're their lawyer, conservator, trustee. In 2000, I think it was 15, they actually had a will where the conservator made a will giving the property to him. But of course, the conservator was related. In fact, in every fact pattern I've seen over the last 10 to 15 years, everybody's been related who kind of does that. But undue influence is usually procured by somebody related to the testator. So it has to be a fiduciary, like a trustee, conservator, lawyer, or care custodian, which I've never seen them do. And the care custodian has to be active in their duty. The actual phrase is, care custodian of a dependent adult, but only if the will was executed while the care custodian provided services to the testator, which is exactly what Sam's doing. So I guess you can, excuse me, what I said, never got tested. The care custodian right there, I wouldn't necessarily, he's not a fiduciary. He didn't draft it, she's the one who wrote it. But here's the thing, the statutory ones do not apply because the person's related. So all this is out if you're related. Do you bring it up? Absolutely. The examiners want to see if you know it. They want to see if you know how to apply it. So even though he's caring for, and even though they're kind of in a confidential relationship of parent and child, maybe it's not so much of a fiduciary relationship like trustee or however you want to have it, or you could say he's a care custodian, but the fact that he's related completely obliterates the statutory presumptions, so the court can only rely on the susceptibility, opportunity, unnatural, and participation. Okay, now the last sentence in 2010, it says, by this time the church had gone out of existence. Well, it brings up another heavily tested issue. As you see, Will's essays tend to be very easy because they do the same thing all over and over again. Most subjects actually do that. Wills in particularly don't. It just stays in a box and it doesn't really go outside that box. Okay, so the next one, I'm going to go back. I'm going to go here. I have to get rid of these guys for right now. So, and this is exactly the way you write your essay. 2004, 2008, 2010, and just go in order. Now that the church is gone, the gift to church lapse. And what lapse means is that the beneficiary predeceased the testator. So Benny dies before testator. And of course, Benny means beneficiary. So now that the church lapsed, when you bring up lapse, California has a statute that saves the gift at lapse. It's called anti-lapse. But in order to apply anti-lapse, the beneficiary must be blood relative of the testator. And the church is not a blood relative, so anti-lapse will not apply. Anti-lapse only applies when it's your brother, sister, parents, a child. Mostly what the examiners test on is brother, sister. They like doing the sibling things where the siblings leave one of their kids. But here, anti-lapse is not going to save the gift because they're not kindred. That's the technical word. Kindred means blood relative. Okay, 2011, finally she dies. Am dies. And guess what? We're done. I mean, that's it. That's how simple this really was, if you think about it. Now Dot's going to try and make one claim, and I don't, the examiners were technically looking for it, but I think you could have easily left it out, almost like I did here, because one of Dot's arguments, what's going to happen is, if the court finds that the 2010 will is valid, because it's a valid holographic will that incorporates by reference or integrates the 2004 will, assuming there is no undue influence, or the court finds that the undue influence, because the proponent has to prove it. And Dot's probably going to be the person here pushing for it because she's the one who's getting left out. So this is what's going to happen if the 2010 will is valid, because it just reverts to this. Actually, church ends up lapsing, and so this goes in by intestacy. It goes to the residue, which would go by intestacy, which means 25% to Sam and 25% to Dot, because her children would share per capita. That's the only one you need to know is per capita. 25% to Sam, 25% to Dot. They take equally. So Sam will end up getting 75%, and she'll end up getting 25%. Dot might want to make a claim for pretermitted child. Pretermitted, omitted, same exact word. But she wasn't accidentally left out. In fact, in 2004, she was intentionally left out. We knew she was alive. I think it's a very weak argument. And if you left it out, totally fine, because it's such a minor issue here. The examiners technically were looking for it, but because it says she was intentionally left out, her daughter, so that brings you up to one of the things of pretermitted children is a child born or adopted after the execution of all the instruments. That means she would have to be born in 2011, takes the intestate share, unless, of course, you were intentionally omitted. There was one or more children, and the testator left it all to the other person's parents, which means if May died, she would leave it all to her husband, which would be Sam and Dot's dad, or they provided for the child outside of the will, like a trust, bank account, something like that. So that's what happened if this 2010 will is valid, but if the 2010 will is not valid, then it goes by intestacy, which means it goes Sam 50, Dot 50. And that's it. And you have to tell the examiners there's an alternative, because I think this issue is quite open. It could go either way. I think a judge could go either way, and for any of you who've ever been in court or about to be in court, congratulations on passing in advance. You're going to have to deal with these kind of things, and you'll know judges make up their minds whatever they see fit. But that's it. That's a wrap. That's all there is to discuss on this essay, and that was the July 2012 wills, question 5. Thanks a lot. We're done.